Hi everyone, I'm Dale Smith, aka Journo Dale, and we're here to talk about Canadian politics. All right, we're here this week with David Fraser. He's an internet and privacy lawyer at McInnes Cooper in Halifax. One of my current bugaboos right now is lawful access, because every single day in question period, Ruby Sahota, Sean Fraser, or Gary and Ananda Sangari will stand up and say, you need to pass our lawful access bill because police need these tools. And the Supreme Court has twice ruled that lawful access is unconstitutional. So I know David has some particular concerns with this bill. So David, why don't we start there with pushing this particular notion once again?
Yeah, I'm not sure they've actually made the case for it in any meaningful sort of way. So in Bill C2, there were two parts. There was Part 14 and Part 15, and they're quite different.
Mm-hmm.
Part 14 is the ability to get information from electronic service providers and, well, anybody who provides services to the public. So it goes well beyond kind of telcos and ISPs. And Part 15 requires electronic service providers to build a whole surveillance infrastructure on behalf of the government. And really, nobody's made a good case for either of those, except I think that there's kind of a case for part of what's in Part 14.
Okay.
But they've done it in a completely bonkers sort of way that has shot themselves in the foot as they've done it. So I regularly, on behalf of companies, review production orders and requests from police looking for information related to their customers for a whole kind of range of reasons. And so I guess I have some insights on the non-law enforcement side of these sorts of things.
Right.
And so regularly, like this happens all the time, a big American company will detect child sexual abuse images on their systems.
Yeah.
They, under American law, have to report that to the National Center for Missing and Exploited Children in the United States.
Right.
They take a look at it. They say, oh, well, this IP address is a Canadian IP address. So they refer it to the RCMP. The RCMP takes a look at it and says, well, we've got an IP address. It says it's a Rogers or a TELUS or a TechSavvy or whatever, but we don't know who the local police of jurisdiction is. Is this Montreal? Is this Calgary? Is this Vancouver? Is it, like, where is it?
Yeah.
And so they go to the telco and say, look, we think this is your IP address. Is it your IP address? And where is the customer located? So so right now, most telcos don't give that information without an order.
Right.
And that's not identifying information. That's like, okay, well, what police agency should we refer this to? So it makes sense to do that or to be able to get that information just to start the investigation. Otherwise, all that stuff would be done out of Ottawa through the RCMP.
Right.
Which, perhaps wouldn't be a problem because those people are specialized in dealing with child sexual abuse imagery investigations. But, they want to send it to the local police. So that makes sense. But the way that they've written it is that any cop can require anybody who provides services to the public, which includes like your doctor's office, to identify whether or not they provide services to that person. And do they know anybody else who provides services to that person? And so that identifier could be your name, David Fraser. Oh, I know David Fraser goes to this doctor's office. Do you provide services to David Fraser? Yes, we do. Is there anybody else, like a specialist, like a psychiatrist? Who is that person who provides? So a whole lot of more biographical information is captured in what they drafted. And they did such a poor job of drafting it because they lowered the thresholds and they expanded the scope well beyond what could be justified.
Right.
And so that's without a warrant. And so that's the warrantless piece. So the rest of the stuff is generally with a warrant, other than kind of emergency and voluntary disclosure. So they have a production order for subscriber information. So right now, if the police want to know, oh, hey, TELUS, Shaw, TechSavvy, whoever, could you give us the customer name and address associated with this IP address or with this phone number? They go to a judge, a justice of the peace, so it might not even actually be a person with a law degree, a justice of the peace, and say, hey, we have reasonable grounds to believe that the person associated with this IP address committed this offense. And we have reasonable grounds to believe that this internet service provider, this telco, has information that could lead to the identification of the person. So please give us an order that requires them to provide the customer name and address associated with that so they can go and then further their investigations. That's with reasonable grounds to believe an offense has been committed. and reasonable grounds to believe that the telco has the information. So what they proposed in C2 is lowering the threshold to reasonable grounds to suspect, which is like a spidey sense.
Yeah.
Like that's the lowest threshold recognized at law in our legal system. Otherwise, it's just kind of on a whim or a fishing expedition.
Yeah.
And this new production order for subscriber information requires, like, the judge has to issue the order for subscriber information, and subscriber information goes well beyond what's necessary to identify the person associated with that IP address or that phone number. And so that name and address, okay, that's fine, but not fine with that threshold. But also device identifiers, so IMEI and IMSI numbers and SIM card identifiers, but also any information that was provided by the customer to obtain the service. And so who provides services to the public? Not just telcos. If I go to an after-hours clinic, for example, in order to get some sort of medical care, they can get a production order on this reasonable grounds to suspect that would require the doctor's office to hand over all the information that I provided in order to obtain the services, which would include my medical history, which would include all that sort of information. You know, even if they just go to a telco, what did I have to provide to obtain the services? A username and password. So, like, this is ridiculous. The incredibly low threshold and the vast expanse of information they're looking for. And then, to make it harder to challenge these sorts of things, Part 14 says, in order to challenge one of these, you have to do it within 5 days of the date of the issuance of the order. And frankly, I've seen orders that were issued on a Thursday before a long weekend and didn't appear at the service provider until the Tuesday, and there's no opportunity for the company to even consider, is there a reason why we would want to challenge this?
Yeah.
And so, man, they've really done an absolute. Now, it's not as bad as some of the previous attempts, which were like completely warrantless, without any sort of judicial supervision.
Right.
But they don't fix the problem of Spencer or Bykovitz, the two Supreme Court of Canada decisions. Spencer said, "Oh well, you can only get this information in response if you have a court order or pursuant to a reasonable law." And so I think they're trying to create that reasonable law, but they've done it in such a bonkers way that it ultimately will be found to be unconstitutional. And why would they do that? Why would they go to all this effort to come up with a law that is ultimately going to be found to be unconstitutional, unless they're just trying to set up a fight with the courts over these sorts of things? And frankly, like, liberal governments have introduced this sort of stuff in the past, and it's fallen off the order paper. Conservative governments have on multiple occasions fallen off the order paper because people have gotten upset about, this is ridiculous, that this is, your entire life is mediated online.
Yeah.
But this goes well beyond the online. This goes to your doctor's office, your hotel, your bank. And in some of the technical consultations, they've said, oh, well, yeah, no, we absolutely intended that this was going to apply to hotels. And I also had somebody tell me, oh, well, we would never issue a production order to a hospital or a clinic. I've seen production orders naming hospitals and clinics. Like, and so that's deeply problematic. So there's been a significant amount of, I guess, I'm going to say dishonesty associated with defending what was in C2 in Part 14. Part 15
I can talk about in question period. You know, Ruby Sahota will stand up and say, it's taking the court 6 months to get information on a cell phone number. And I'm like, I have spoken to former judges who used to sign off warrants on terrorism suspects. Like, she told me point blank, if they have, police have their evidence in order, it's no time at all.
So, absolutely, yeah. I've seen, and in fact, on my YouTube channel, I did a video related to them trying to revive lawful access. And Ruby Sahota talked about, oh, people are kind of fleeing their houses have been shot up, and it's taking 6 months to get... She was in Brampton, I guess. Yeah. And so I found a case out of Brampton. It's like, no, within a couple days, like less than a week, they had a production order, and it wasn't related to shooting up a house. And so
the shooting up the houses is more what's going on in Surrey right now. But again, I've heard nothing that actually substantiates the 6 month claim that she's making.
Yeah, like the only thing that I can think of is either the police are not competent, which I don't believe is the case. I think police are generally quite competent. They don't have enough information to create the reasonable grounds to believe that a crime has been committed. And frankly, bullet holes in a wall is pretty convincing evidence that a crime has been committed. So I don't know where that's
And
where
if
that's
they're reading
coming
the
from.
extortion letters in the House of Commons, I mean that should be reasonable enough grounds for police to be able to go to a judge.
I don't see anything in C2 that fixes that.
Yeah,
That if that is in fact the case right now, where you can get a general production order with reasonable grounds to believe an offense has been committed, and frankly, if it's too urgent to go into a courthouse, they can get it over the phone.
yeah,
So I think they really have to substantiate those sorts of allegations. But frankly, like at the press conference where they tried to revive it, that I watched a number of times, because it really just didn't make a whole lot of sense to me. It's like, that the politicians were reading scripts that they hadn't seen before
yeah,
was really a sense of it. Like somebody put them out there in order to try to defend this without the firsthand or real knowledge, even secondhand knowledge, in order to understand kind of what's going on. So I totally get this is a huge wish list for the cops.
yeah,
Who wouldn't want to find a way to do less work, or to be able to kind of short circuit and skip processes? But the processes that you're potentially skipping, like that's the Charter of Rights and Freedoms. Like
yeah,
that's our ability to go through our daily lives anonymously and without interference by the police, unless a judge says yes, that the equities in this case mean the public interest in investigating this particular crime outweighs this individual's privacy interest at stake.
yeah. The other thing you had previously spoken to me for a piece that I'd written earlier was about this kind of backdoor access that they're trying to mandate. Is that part of this particular bill as well?
Yeah, so that's part 15 of what's in Bill C2.
Okay.
And certainly everything that I know right now is that they are going to reintroduce all of it.
Yeah.
After some significant consultation, and I think kind of good faith consultation, but good faith consultation with the objective of trying to find something that they can get passed without the kind of objection of all the opposition parties. And so I think we're going to see something that's going to be introduced, it's going to be improved, but I haven't heard a whole lot of discussion about Part 15. And Part 15 creates a new statute, the kind of authorized access to information act, or something else like that. And what that does, it's kind of modeled on a law from the United States called the Communications Assistance to Law Enforcement Act that was passed in 1996 in the States, or around then. And all of a sudden, Canadian police and national security folks became incredibly envious of that thing.
Of course they did.
And in the States, it's limited to telecommunications, like to traditional kind of telephone. But they're looking to have it expanded. And so there are two kind of main affected organizations. There's your core providers, which would be Bell and Telus and Rogers and Shaw and kind of the big telcos. And there would be regulations that would say, hey, you need to have these sorts of intercept capabilities built into your systems. So essentially, you have to build backdoors that the police can plug into, theoretically, in order to act under a warrant. So if there's a warranted request, did a hand just go up or something?
It did. Yeah, that's fine. Well, we'll just ignore.
Okay. Yeah. So this essentially requires that the telcos build in a backdoor that the police can plug into, theoretically, if they have a warrant, like an intercept order or something else like that, so that they can do what they need to do under that warrant, real-time access to intercept communications or text messages and things like that.
Right.
And so that's going to be relatively transparent, because that's going to be in regulations. But I'm not sure that that's actually necessary, because these big telcos respond to these production or these intercept orders all the time. And those intercept orders can also be accompanied by an assistance order, which says, hey, TELUS, you need to do whatever is necessary in order to give effect to this particular intercept order. So that's already there. but they want to prescribe, hey, this is the technology. You need to use the Widget Co 6225 law enforcement intercept switch at this particular place in your system. And what this means is that every telco will have to implement that widget in their systems, which we've seen in the United States. Chinese state-sponsored hackers are persistently using the CALEA, the Communications Assistance to Law Enforcement Act, prescribed technology backdoors in order to intercept and get U.S. communications. And the U.S. telcos have said, there's no way we can get these guys out of our systems. That like they're there and it's here. So this would require all our Canadian telcos to have these sorts of features or bugs, depending on how you think of it.
Yeah.
No, it does say, hey, look, you don't have to comply if doing whatever it is would introduce a systemic vulnerability into your system. But the government gets to define what is a systemic vulnerability.
Of course.
And it doesn't allow them to improve their systems to make them more secure. Because if the government says, well, on day one, you have to have this capability, and they say, well, a year later, they think, oh, well, we could do a much better system configuration, they can't backtrack because they can't cut off that particular access. What's also troubling is that there's a second piece of it, which is anybody who provides electronic services, which is obviously like a telco. It's Dropbox, it's Google, it's Zoom, it's Teams, it's all these other but it's also like an online gaming platform like Xbox. Mm-hmm. It's like Wordle from the New York Times, but it's also the Canadian Press and the CBC website, because that provides electronic services.
Yeah.
They can be subject to a secret order requiring them to build in intercept capabilities or to those sorts of backdoors. That can be VPN providers, which VPN providers by definition are there to provide secure communications. It's like, oh no, we're going to order you to do this. And then it's a secret order, there's a gag order. You can't talk about it with anybody. It's subject to very narrow judicial review and kind of review by the minister, which is no review at all, in my opinion.
Yeah.
And no requirement for kind of proportionality or there's some, oh, well, they have to consider the equities of kind of how important is this to law enforcement or national security or things like that. But all of these are secret. So they happen in the shadows.
Yeah.
And subject to very, very little review. And when you talk to the folks at CSIS, there are bad guys who are using the messaging function of gaming platforms and other things like that. But again, they could be served with an intercept order and an assistance order for that one-off. And that would mean that a judge would have had to have considered the equities.
Yeah.
But in this case, no, the minister does. And in this case, I don't have a lot of confidence in the current minister as to whether or not he's just kind of signing off on what others are asking him to do.
Yeah.
And then there's this whole kind of regulatory stuff. Like you can't do anything these days. So there's this whole kind of regulatory bureaucracy. So the minister can designate anybody who gets to go into any electronic service provider and audit all of their systems and unplug things and plug things back in and examine any records. So, an electronic service provider, like, that's your telco. It's like, oh, I get to examine any record. I would like a list of all of your customers. Like, there's no proportionality, no necessity.
Yeah.
And anybody who's a police officer or who's an employee of CSIS can go to any electronic service provider and say, I want to check out your systems. As you can imagine, like a lineup out the door at Bell Canada of every municipal police department with somebody who's like, oh, what... I'm just kind of curious. So, like, no limits on it whatsoever.
Yeah.
And so I don't have any. I'm optimistic that they might fix Part 14 related to these orders because one of them is useful and proportional to the cases they've asked for. Part 15, not at all. And one of the things, like I heard from this is kind of off the record theoretically, but it's like, oh well,
we were on YouTube, so.
Sure, nobody's watching.
All right.
We were once like following this guy, and we knew his cell phone, but the telco couldn't track his cell phone in real time. And it's like, so you want to be able to order a telco to build in a tracking capability that they never needed, never wanted, never deployed. And it can go so broad as to, oh, hey, Amazon, we want you to route all these Alexa devices to turn them into listening devices.
Yeah.
That is ridiculous. So, like, theoretically, if you had a really bad guy with an Alexa device, sorry if I'm triggering people's devices, with an Echo device in their house,
Yeah.
they could go to a judge, the federal court if it ceases, or if any other court if it's like the RCMP, and say we need this order and we need an assistance order, and the judge would look at that particular case and but it could apply like across all these technologies, and it's like, that is so completely disproportionate to any case that they've made for why they need this. So.
Yeah. Well, all right. Well, on that cheery note, thanks again for doing this. I will link to your YouTube in the description below because there's some really good stuff in there. I'm going to recommend people check out your video on the age verification bill because I think that's another one that needs to die in a fire, but that's my particular perspective on that. Thanks again, and hopefully we'll do this again in the future.
Sounds good. It was a pleasure. You take care.
All right, thanks. And that's everything for this week. Join us again next week for some more Canadian politics. I'm Dale Smith. That's at journo_Dale on Twitter and journodale_no_ on Bluesky. And don't forget to like the video, share, subscribe, and support us on Patreon. Thanks, everyone.